In this session we will see about the liability under a government contract. Article 299 clause 1 says all government contracts should be entered in the name of the president or governor. Simply because it is executed in the name of the governor or president, they don't incur any personal liability. That is why Article 299 clause 2 says the president and governor will not be liable for the contracts, for the government contracts. Now next we will see about void contracts. The contract is void if it is not in the proper format or if it is not entered with the proper authority. If a person without authority entered into a contract, then it is a void. What is the portion if the contract is found out to be void? For example, a person, an executive engineer, placed an order to construct a building. The other person completed the job. After that, they found out that this executive engineer don't have that authority, or the contract was not in proper format. It is a void contract. The builder cannot claim money from the government. Originally, they were applying Article Section 230 subsection 3 of the Contract Act. Section 230 subsection 3 of the Contract Act deals with the agency. Agent is liable for the agent can make the principal liable for any act provided it is within his scope of authority. If he acts anything beyond that authority, then agent is personally liable. They applied the same rule here. Government is the principle that officer is an agent. If he is doing something beyond his power, then he is personally liable. But subsequent to that, courts held the contract itself void. So there is no authority as a principal or agent. It is a void contract. The officer is not liable under the section 230 subsection 3. Then what is a remedy? Remedy is section 65 and 70. Section 65 of the Contract Act says any benefit received under a void contract, the other person should compensate for the benefit. In this case, the government has been benefited because the other person has constructed. Now the government has to compensate the other person for the building. Section 70 also deals with that. Non-gratuitous act. If it is an act, non-gratuitous act, the other person has to compensate. Here also the builder has constructed for money. He has to be paid. Section 65 and Section 70 of Contract Act is the remedy for the persons under the void contract. Article 299 does not say anything about how to enter into a contract. What is the procedure for entering into? Before 1975, there was discretion for the government. They were entering into a contract according to their choice. In C.K. Achyutan versus State of Kerala, it was held that the government has the discretion to enter into a contract. With whom they have to enter, they will decide. But subsequent to that, because of the welfare state functions, there were too many contracts with the public. In 1975, Eurasian Equipment and Chemicals Limited versus State of West Bengal, it was held that the government did not have any discretion. It is not like individual, they should treat everybody equal. Same thing in Ramana Dayaram Shetty versus International Airport Authority. International Airport Authority case, it was held that government has no choice, no discretion. They cannot discriminate the people. They are bound by the standard. They cannot make a departure from the laid down standards. So now the government is in a stage that they have to treat everybody equal. Same is the case in another one, Tata Cellular versus Union of India. There the Supreme Court held, you have to see the Article 14. All should be treated equally. Article 14. Subsequent to that, Maharashtra State Road Transport Corporation versus Reliance Energy. In this case, the court held that the government should see that Article 14 and also 21 are complied with. So everybody should be treated equally. Okay. Then regarding the judicial scrutiny, whether the government contracts can be scrutinized by the court. The rule is they have to see only whether all are treated equally. That is the main thing. They should not go deep into the terms of the contract. What they have to see is three things. One is whether any illegality, whether there is any irrational, or whether there is any procedural lapses. For example, if tenders are given only to 4 persons known to the manager, known to the executive engineer, then it is not procedure. Procedure, as per our procedure, it should be published, all the persons should be given tender forms. All should be treated equally. If it is lowest, the person who has quoted the lowest price should be awarded that. These are things they should see. They should see everybody is treated equally. There is no procedure lapses, but they should not go into the terms of the contract and see that it is unreasonable, it is unjustified, all these things. This is the general rule. Next rule is they have to give the contract to the lowest price, person who has quoted the lowest price. If it is a sale, by the highest price. This is the rule. But if the rule is applicable only when all are equal. If the person gives the same standard of goods, then he can claim I am also quoting the lowest price. But if there is any changes, then the lowest price concept will not come. The lowest price comes when all things are equal. When the lowest person is not giving, then the government authorities have a right to negotiate with the second person. Award even without tender contract can be awarded even without tender also if special circumstances is there. Next one, whether writ can be filed for government contract. Writ can be filed when it is against the fundamental rights. Fundamental right is to treat everybody equal. If the government person favored somebody, then they can file a writ petition. The procedure is not there. For example, the same thing. For tender form given only to 4 persons, that means it is against the fundamental rights. Writ petition can be filed for fundamental rights, but writ petition cannot be filed after the completion of the contract. If there is breach of contract, writ cannot be filed. They have to file in the civil suit. In the same way, for sale of property also, government Supreme Court has formalized some procedures. They should give the fixed price. Reserve price should be fixed. Public auction should be conducted. With all these things, we see that government contract should be as per the norm. Everybody should be treated equally. No favoritism to anybody. No discretion. We will see some other chapter next time.